Chuck, we need your expertise here to walk us through this. Let's first talk about those statutes that Ken artfully put into the record for us this morning first. Talk us through each one of these statutes and what they could potentially mean in terms of charges.
Sure, and I'll take them in the order that they're on the screen. So deprivation of rights under color of law really means an official, in this case a federal official, Mr. Trump, acting in some way to deprive another person or class of persons rights guaranteed by the Constitution. So there's various ways, Ryan, of violating this statute. We don't know yet who the victims are for purposes of the indictment, and we don't know specifically what rights they were deprived of, although there is a section under this statute that speaks to voting rights, and I think that would be a good guess. The conspiracy to defraud the United States, as Ken Dateline so ably laid out earlier, was an attempt by Mr. Trump and others, his co-conspirators, allegedly to thwart the peaceful transfer of power and to overturn a fair and free election. And then tampering with a witness is a bit of a misnomer in the following way. The statute is entitled witness tampering, but there are many sections to it and many different ways of violating this particular statute. And one of the ways in which it can be violated would be to essentially obstruct an official proceeding, in this case, the counting of the electoral votes. And by the way, Ryan, a lot of the January 6th rioters, certainly the ones who are higher placed or more culpable, were charged precisely with that piece of the witness tampering statute, right? An attempt to essentially impede the lawful function of the government.
Well, that's interesting because, you know, there's a conversation over whether or not the special counsel was going to focus on the overturning of the election versus inciting the mob at the Capitol. So there's a potential that both of those incidents could fall under these potential charges. But I have to ask you, you know, are there other potential statutes that could be invoked? Like, for instance, we don't see the potential of a seditious conspiracy charge, at least in this target letter. Does that not necessarily mean that that could come up once the indictment is handed down?
Well, it could come up for a couple of reasons, Ryan. One is there's no obligation that prosecutors even send a target letter, let alone that they enumerate every possible statute with which a target might be charged. Then second, and Ken also alluded to this, there are ongoing grand jury investigations. There may be additional charges. By the way, there may also be other defendants. We always talk about this as if Mr. Trump is the only target and therefore the only potential defendant. But we saw in Mar-a-Lago that one of his aides, Walt Nauta, was also charged. So there's a number of ways in which other statutes might be invoked and might be charged. Right now, that would entail a good deal of speculation, but it's possible, certainly possible.
And does it necessarily mean this could be the end in terms of federal indictments for President Trump, former President Trump? Could there be more in the future? Is there any reason to think the investigation isn't ongoing?
Well, there's a reason to think that it is ongoing. I mean, Ken mentioned that other witnesses were appearing in connection with the Southern District of Florida federal investigation. We know there's more work still being done in the federal investigation in the District of Columbia. So it's always possible. Again, there might be other defendants, there might be other charges. There could be superseding indictments, meaning you could indict Ryan Noble and Chuck Rosenberg for conspiring to rob a bank, and then learn that we conspired to rob a bunch of other banks and supersede the indictment with those additional charges. There is a problem, though, from the government's perspective with these ongoing investigations, should they lead to superseding indictments. And that is, it would inevitably slow the case down. Government doesn't want that. They want a speedy trial. Jack Smith has been clear that he wants to move these cases to trial as expeditiously as possible. And so I think there would be some concern if the government will continue to investigate and continue to supersede its indictments. Hopefully, what we see next would be, and when I say hopefully, I mean, my hope is that if the government's going to bring charges, they do it singularly, thoughtfully, comprehensively, and that this doesn't continue to just sort of turn on and on and on.
Okay, and then quickly, before we wrap up, how important will jurisdiction matter here? Will this come down in D.C., or could they bring it out of a place like Arizona or Georgia, where we know that they've issued subpoenas to officials in those states?
Yeah. So, Ryan, you're referring to venue, the place where the crime occurred. And typically in large, sprawling, complex cases, you could have venue in any number of places. If the concern is the jury pool, I have a view that you can assemble a fair jury anywhere, that Mr. Trump and the government can get a fair trial in the Southern District of Florida, and that Mr. Trump and the government can get a fair trial in the District of Columbia. That relies in large part on the judge and the lawyers in the case screening jurors and asking the proper questions. But I'm not overly concerned about venue. I think both parties, as they should, can get a fair trial wherever the case is venued.
Venue, not jurisdiction. I learn from you every single day, Chuck Rosenberg. I appreciate it. Thank you so much for being here. You really helped us to understand what this target letter means.
Thanks for watching our YouTube channel. Follow today's top stories and breaking news by downloading the NBC News app.